Welcome, everyone. This is Alan Franklin from the Athabasca University Faculty of Business. I'm the moderator of this webinar, and I want to firstly welcome those of you on the West Coast. Good morning. For those of you in the rest of Canada and the US, good afternoon. And to those in Southeast Asia and Australia, good Saturday morning to all of you. I want to welcome Pascal Collat, who was the Canadian National Contact Point, to talk to us about the NCP, its role in Canada, and why Canadian companies should be keenly aware of the NCP system. Pascal will give us some examples of situations she has dealt with over the past few years that will help us to understand the importance of this. The timing of the webinar is actually quite auspicious because the federal government has recently announced the creation of the Canadian Ombudsperson for Responsible Enterprise, referred to as CORE, C-O-R-E, which will replace the existing CSR counselor. The CSR counselor will be abolished in May of 2018. The new ombudsperson hasn't been chosen yet, but according to Global Affairs Canada, the new office should be operational by September 2018. The role of the CORE program is somewhat similar to the NCP in that it will investigate allegations of breaches by Canadian companies of human rights abroad. However, it will focus initially on mining, oil and gas, and the garment industry only. Now, for those of you in the audience who attended the in-residence in Washington through our program last year, you will recall that we met with Malika Yetkin at the United States Department of State. She's the U.S. national contact point. Pascal, as the Canadian contact point, will talk today a little bit about some of the differences between the Canadian and the U.S. systems. Now, Pascal will be discussing the OECD guidelines for multinational enterprises, as we see on the screen. These are guidelines, so they're not considered binding law on corporations. Because of that, they're often referred to as soft law. Now, Stéphane Brabant, a lawyer in Paris who's considered the leading lawyer on business and human rights issues globally, said to our Athabasca students last year in a webinar that is available on the Athabasca site that soft law can result in very hard consequences for companies that do not comply with soft law. So Pascal will be discussing some scenarios today that will give examples of how these soft law concepts can result in hard consequences for Canadian companies. Now, just as a housekeeping matter, hopefully you can all see the screen with the PowerPoint presentation, and hopefully you can all hear me. So I'm going to ask you just to go to the box on the right side of your screen that has the questions box, and you can each type in a question just so that I can know that you can hear me. And if you can't hear me, put that into the question. Or I guess if you can't hear me, you won't know to put it into the question. But I just want to make sure that people can hear the presentation all over the world. Because it's going to be recorded and posted on the Athabasca site after the seminar is completed. So without further ado, I want to welcome Pascal to this webinar, who's going to give us a presentation on the NCP system. So thank you, and please take it on, Pascal.
All right, thank you so much, Alan, and to your faculty for the opportunity. And hello, everyone. So today I'm planning to, right now I'm on the slide that says what we will talk about today. I was going to give a bit of an overview, and Alan already introduced that, of the OECD guidelines and what exactly is this little booklet about. And then I was going to spend a little bit of time as well on a very important concept, which is called in the guidelines the due diligence on responsible business conduct. And not by any means that I was going to pretend to be an expert on that, but I think this is very important, and the OECD is developing a lot of work on that. And then the bulk of the presentation, like if I can say, was going to be describing our NCP process, how it works, with examples and statistics, as Alan outlined. So now moving on to slide 3. So what are the guidelines? As Alan, you have said, they are voluntary for companies, but what very few people know is that there's actually, at the back end of this document, there's also some binding things for governments. And these guidelines are the most comprehensive set of guidelines out there on responsible business conduct. And they have been endorsed by 48 governments. So it's the OECD family of the rich club, quote unquote, plus 13 non-OECD members. A few of them are listed on the slides. Some G20 members, but also others like a few Latin American countries, and now we have also Kazakhstan joined it. And these people, these 48 countries, have adhered to the OECD Declaration on Investment and the Multinational and Enterprise Guidelines more than 40 years ago now. Basically, these guidelines, I will explain later what they say, but they have been endorsed as well by partners at the OECD, so not just the government, and that makes them very particular. But of course, because they apply to companies, they couldn't be developed without stakeholders, and in particular the business community, but also the trade union advisory committee at the OECD, and a group called OECD Watch, which represents the voices of NGOs at the OECD. So next slide, number 4. So these guidelines, what do they cover? I mean, here on the slide, you can see the list of all the chapters. I'm not going to go through in detail, but basically, this is quite encompassing. And the core ones, obviously, are the disclosure, human rights, environment, and labor, called employment and industrial relations, but also some issues around, as you might imagine, corruption, bribery, and then also taxation and competition. And a lot of these standards are based on good corporate governance standards that many of you might already be familiar in terms of, running a good business. But they extend, as you can see, much wider. And in particular, the human rights chapter was introduced in 2011. So that's when the guidelines were last updated. And the key upgrades were the new chapter on human rights. And that chapter is totally aligned with the United Nations Guiding Principles on Business and Human Rights. Some of you may be familiar with that. I was not going to go into detail on that, but this UN Guiding Principles have requirements for states to protect human rights, but they also have requirements for businesses to respect human rights. And the two instruments are totally compatible, if not word for word. Another main upgrade in the 2011 update was the introduction of due diligence concept, and we will talk about that later, and also upgrades to the environment chapter and to the stakeholders engagement requirements. The guidelines, and a thing that is really important to understand is that companies have to respect regulations and laws in the country where they operate. That is not of debate. But what the guidelines do is in many cases, they extend beyond the law. They're going to say, you should do more in many, many areas. And basically, they're trying to raise the bar. A lot of the topics covered in the guidelines are also covered in many countries, especially OECD countries, by law, but they also go beyond. For example, the due diligence is not covered in large extent in many ways in Canada. So it is definitely trying to push businesses to do better, I guess. So these guidelines they come with a unique feature, which is the national contact points, which we'll talk about later. So if we move on to slide 5 now, the applicability. So that is often a subject of discussion. Basically, the guidelines cover all sectors, first of all, of the economy, all companies. They also cover all sizes of companies, and people think, okay, they're called multinational enterprise guidelines. Well, therefore, small companies shouldn't be covered. Well, as a matter of fact, they are if they have international linkages. And as a matter of fact, we could also say, and the guidelines also say, that the guidelines also apply to quote-unquote domestic companies. But they obviously are designed with a view, embedded in the investment declaration. They're designed to companies that have international operations, and they apply to all entities within the company, whether they're subsidiaries or parent companies, and in every country they operate. And as I said earlier, they're not a substitute for domestic law, but they're complementary, and they go beyond. They also apply to both private and publicly traded companies. And in Canada, they apply to crown corporations. For example, I'll talk a bit later about Export Development Canada as a crown corporation. So basically, state-based enterprises, state-owned enterprises. There is no definition per se of multinational enterprises in the guidelines, and the national contact points have a lot of latitude in how they interpret the text. There's, however, a description in the chapter on concept and principles, and the international linkages or activities of the companies is a sufficient test for the applicability there. The guidelines, I said earlier, apply to all sectors. I'll say a quick word about the investment sector, because a lot of private sector and even public authorities didn't think at the beginning that the guidelines apply to the investment and the financial sector. In the Canadian NCP history, we haven't had a complaint in this sector, but it's only a question of time, I believe, until we do have a case there. And this sector is the most rapidly growing sector in terms of new complaints coming in to the network of 48 NCPs. And in the vast majority of cases, it could come as a surprise, but minority shareholders would be directly linked to potential negative impacts that are caused by companies in their portfolio. We'll talk about that a bit later when we discuss the due diligence. So now slide 6. I've already actually started to allude to that. So the nice feature of the national contact points and the guideline is the extraterritoriality, so to speak. It's a concept that is very difficult to apply or less present in law and international law. But the guidelines do follow the business where they operate. So a Canadian business operating in the middle of Burundi would be expected, and the Canadian government certainly expects that, and the national contact point expects that they do abide by those standards. And the guidelines, as I said earlier, in terms of the due diligence, they bring this sort of fairly recent concept. Is that, I mean, it's already a few years old, obviously, but companies have responsibility in relation to their supply chains and their business relationships, and we're going to talk about that. The guidelines say that an enterprise should seek to prevent or mitigate actual and potential adverse impacts and risks. So, I would stress the actual and potential, and the impacts and risk. I guess risk are the potential aspects of that. And in terms of risk here, we're talking about not just the risk to the company here in terms of, we're not talking about a financial risk in terms of material or, the bottom line of the company or on the investee or investors, etc., which is the traditional meaning, I think, in the business world of the word risk. But we're talking risk to persons, to the environment, and to society. which is at the core of the corporate social responsibility topic. And basically, the impact or the risk here that we're talking about is related to all the chapters of the guidelines. So risk with respect to labor or impact, risk on human rights, on the environment, on disclosure, on due diligence. So we're talking here about company activities or actions, and an action can be an actual action, but it can also be an omission. So you can also be guilty, quote unquote, by omission. Now, before digging into the sort of degree of responsibility, I want to say a word about business relationships. What is that? What do we mean by that? There is not a definition per se again, but it is basically all types. It's very encompassing. It's suppliers, licensees, joint ventures, investors, client contractors, customers, subsidiaries, financial, legal advisors. I mean, it is, and again, I mentioned the state entities that also could be linked to business operations. For example, Export Development Canada, providing financial support to a company for exports is linked by business relationship to a Canadian company, which is private, but then EDC would also have some responsibility, first to apply the guidelines for themselves, but also could be determined to have some responsibility in an impact that the company that it provided support to may cause in another country due to the financial product relationship. So if we move on to slide 7, this is borrowed from an OECD paper. And I don't pretend to be an expert on due diligence, but I think before talking about the NCP, I want to say a word about the due diligence because it's important. What is expected from companies is to do a bit of an assessment, their own due diligence. But what does that mean? They need to identify those impacts and those risks. And they can be in 3 categories, so to speak. They can be directly caused by the enterprise. That's the first box on the left. And basically, an enterprise causes an adverse impact if its own activities and the activities on their own are sufficient to result in the impact. For example, if an enterprise discriminates against women or a minority in its hiring practice, then that's a direct impact, that they caused themselves due to their practices. The second category, which is a little bit more indirect, I guess, but is contributing. They can contribute to an impact. And an enterprise contributes to an impact if its activity, in combination with the activity of another company, cause the impact, or if the activities of the company itself cause, facilitate, or incentivize another entity to cause an impact. So you have to have at least 2 players there, and the contribution must be substantial. So there are certain things that the OECD is developing right now. The source of this graphic is an upcoming publication in May this year by the OECD. So stay tuned for that, and it's called Due Diligence Guidance for Responsible Business Conduct, or maybe the other way around. But this is going to apply generically to all sectors, and it's going to explain basically to companies how to apply the due diligence in a recipe. And I want to talk about the third category before moving to the whole due diligence recipe cycle. So the third category of how a company could have some level of responsibility in terms of responsible business conduct and CSR is they can be directly linked to an impact through a business relationship. And hence the importance of understanding who your business relationships are. Because basically that is a little bit easier to understand than the second category in my mind. It's basically linkage is defined by the relationship between the adverse impact and the enterprise's products, services, or operations through another entity, i.e. through a business relationship. For example, if an enterprise sources some cobalt, I'm not sure I'm pronouncing this word correctly, cobalt, mined using child labor, for example, in the Democratic Republic of Congo, not to name it, and that mineral is used in its products, then the enterprise can be directly linked to the adverse impact, which is child labor. And where we and here we're talking about global supply chains, really, and this is really fascinating because now this really puts the global supply chain on the radar. Not that it was not before, but maybe bring another perspective that for a company, yes, I should be paying attention to what's going on in my supply chain, to who I am sourcing from. Another example recently with the I think it was the Danish NCP, National Contact Point. They had a case with a Danish company in the garment sector that was involved in the Rana Plaza disaster a few years ago, and there was a case coming to the NCP about that. And basically, they said this company had a subsidiary which was operating in the building that collapsed, and basically the national contact point didn't say that the company was responsible for the collapse, obviously, but they digged into it. They did some investigation, fact finding, etc., and they did determine that the company, the parent Danish company, had not exercised due diligence to check that its subsidiaries had in place, adequate fire and safety and building structure inspections program. And they should have. They should have put this on the list of their due diligence to check. And they had some activity related to that, but it was not like a full and consistent, frequently, periodic system in place internally to the company to see where their suppliers and how the suppliers were operating. So this definitely is, to me, a bit of a breakthrough. And Alan, you talked about soft law, and this is where we'll see a bit later in terms of how NCP cases do create soft law turning into not hard law, but some kind of jurisprudence, even though we're not a judicial mechanism. But it would be hard for another NCP to come up with different conclusions if it was presented after the Danish NCP had concluded that. So moving on to slide 8. Now, how the due diligence and the identification of impacts and the level of responsibility that we just talked about, how does that fit in the bigger picture? This is again borrowed from that new paper that's going to come out from the OECD. I guess I'm making some publicity there, but there is a whole due diligence cycle that should be implemented. And it's an ongoing process because due diligence is dynamic and complex. And you basically, we talked about in the previous slide, we talked about the blue aspect, the blue arrow of that circle. Identify and assess your impact, and then you prioritize, of course, because you can't do everything at once. So again, this OECD guidance will give you an idea of how to prioritize because it can be very daunting. Some companies have thousands of suppliers, of course. There's no way, or even a small and medium enterprise that couldn't be expected to do the same level of due diligence than a bigger company with a whole CSR department. So that's the first step. And then we move into the, once you identified your risk, you have to stop them. If you have good reason to believe that you should stop the impact, you should prevent or mitigate. So that's a very important part of the cycle. And then there is the tracking, monitoring your results, your impact. And then there's communicating. I would argue that the communication purple box should be actually at every step of the due diligence cycle, because it is probably in a company's interest to publicize that they are doing a human rights impact assessment, for example, even if they haven't reached the mitigation phase or the prevention phase. They should communicate what they're doing because it could be daunting and scary and taboo, but if it's done correctly, it should probably be They shouldn't be afraid to speak to their shareholders and to their customers and their investors about it in the public domain. Due diligence is also it is best practice, rather, when you do this recipe of due diligence to engage stakeholders. That's a bit of a misnomer, but again, it should be done at every step of the process. And a stakeholder is not necessarily just the local NGO or the local community, but your own employees and your partners and the unions, etc. And again, due diligence is not meant to shift responsibilities to your subsidiary or to other companies, because that could be also an easy, or vice versa. You know, a subsidiary shouldn't push the responsibility up to the headquarters necessarily, just because they have heard that the headquarters should be responsible for doing due diligence. It's everybody's business. So moving on to the next slide, slide number 9. I already mentioned the new guide from the OECD, but there's a whole suite already available for you to download for free on the OECD website. If you Google OECD due diligence, you will find. So I'm not going to go through all of that, but just a couple of words. Basically, there's a pilot right now going on the agriculture supply chain tool. And some companies have volunteered to join that pilot. It's going to be a 2-year pilot, and it's almost like free consulting, really. And some companies are seizing that opportunity. Conflict minerals and the extractive sector. As you can imagine, Canada and the government of Canada is very engage in that sector in terms of corporate social responsibility, given the number of Canadian extractive companies that are operating, or both registered in Canada and operating abroad. And it's there's a huge program of work at the OECD on conflict minerals. I mentioned cobalt. I think now this is ongoing and not yet published, but there is already the 3 Ts and gold. And there's also a special paper on child labor in that sector. And the Government of Canada and the National Contact Point are contributing voluntary financial contributions to the OECD on this work. So these guidance, as I think I already mentioned, what's written in blue there, these tools are really good to help you prioritize, to help you identify, and also to, I guess I never went to that aspect of the cycle, but how you can apply leverage. Because once you've identified your impacts, i.e., or your degree of responsibility, whether cause, contributed, directly linked, it is also your responsibility when you want to stop the impact, or is to assess how much leverage you could have on your business relations, on your subsidiary, on your investee, investor, etc., to be able to determine the appropriate response, which could be in the finance sector, for example, divestment or disengagement, not renewing a contract with a supplier, for example. Recognizing that this can have, obviously big financial consequence so before doing so, companies ought to give it the proper thought. So now, for the rest of the presentation, we're going to talk about Canada's National Contact Point. And basically, on slide 10, you will see that our Canada's Contact Point is basically a committee that is chaired by Global Affairs Canada, here in the Trade Commissioner Service of the Department of Global Affairs under the Minister of Trade. And this is also where the Secretariat is housed. And we have 6 other ministries or federal departments that are around the table, and Natural Resource Canada is the vice chair. And the reason for that is because, as I said, the extractive sector is extremely important, and Canada's NCP has had the majority of its cases, 85% precisely, in that sector. But also we have environment and labor and indigenous affairs, etc. national contact points have the latitude given in the guidelines to arrange their national contact point the way they want. So our government is sort of multi-agency government-based, so to speak. Alan, you mentioned an interest in looking at what our friends to the south have been doing with their national contact point, and they have a different setup. They're located in the State Department of the U.S. government, and they have a secretariat that they don't even call like that, but it's just 2 or 3 people within that department. So they don't, but they do have an interministerial committee that is advising them. But these people are experts. They bring expertise to the table, just like our members. But over there, they're not actual members of the NCP. So it's a little bit different that way. In Canada, we do make our decision by consensus of the 7 departments. If we don't have consensus, majority prevails. So there's not one department or the chair that has a bigger voice. And the US also has a multi-stakeholder advisory body. Now, the Canadian NCP doesn't have a proper advisory committee. We have an informal structure that we call NCP Social Partners, and it's composed of the Canadian Labour Congress, which is a big labor organization that most of you must know, la Confédération des syndicats nationaux du Québec, which is another labor organization but based in Quebec, and the Canadian Chamber of Commerce. And the National Contact Point has existed technically here in Canada since 1991, but our current structure and mandate given by the guidelines is from 2000. And there is a lot of benefits to our structure. I mentioned the expertise, specific expertise. There's a high level of accountability towards our regulatory and administrative requirements because of the 7 department structure. And I mentioned our decision-making governance, which enhances independence from conflict of interest. Now, moving on to slide 11. This is just a quick snapshot of what NCPs are and are not, to give you a feel, and the rest of the presentation will drill deeper into that. So NCPs, if I'm going to start with the right-hand side box. They're voluntary, as we say, in terms of they're not voluntary for us, the government, because we have to have one, we have no choice, but they're voluntary for parties to participate to or to file a complaint to. We're not a judicial body. I've said that. We cannot directly provide compensation of remedy. We can offer mediation or dialogue facilitation, which means that we basically say, oh yeah, there is value here in putting those parties that have a dispute together. There's value in putting them in the same room and discuss and mediate a solution. So the NCP will facilitate that, but he won't impose the remedy. And it cannot either compel evidence from the company, for example, and there is a very part and crucial aspect of our mandate and our procedures, which is about balancing confidentiality and transparency. And I'm sure you understand why, given that, talking about disputes and conflict, there is some also business confidential information can come into play. So these aspects I will touch a little bit more on later. Moving on to the left-hand side box of that slide, it's relatively easy to lodge a complaint, and it's typically faster and cheaper than litigation, although I have to say with the number of cases that the Canadian NCP had in the past couple of years, we've had trouble meeting our own business service standards, but basically it is faster than litigation, and it's solution-oriented, non-adversarial, non-conflictual, and basically some of the good benefits we'll have examples later, but that come out of that is basically it can allow for some behavioral change in the corporate world, important policy changes, and even negotiating actual remedy in various formats. And also it helps build the trust, because often, remember we talked about stakeholder engagement. I mean, might sound a little bit naive, but yeah, if you want to operate in another country and you don't have the good pulse and feel for the community and the local environment, trust can be lost very quickly, and it takes a long time to rebuild, as we all know, and it can be lost in a day. So these kinds of forum that the NCP offers is also valuable for that. And sometimes the value of a mediation, even if there's no agreement at the end of the day between the parties, it still reinstates a dialogue. Moving on to slide 12. So NCPs don't just deal with complaints, and we'll again talk about the complaints later, but NCPs have a mandate to promote, and they have to be out there gaining and maintaining the trust of the public, and they need to do stakeholder outreach. So we spend a fair bit of our time promoting the guidelines, the OECD due diligence, and what I'm doing today is part of that. And we have an annual meeting with our social partners, the 3 partners that I highlighted before. We have an annual information session, or at least a seminar. We do various promotion activities. We have an annual report. It's actually an obligation that we have to the investment committee of the OECD. We recently did some website upgrades at the end of 2017. And hopefully we'll move to a modernized Government of Canada look and feel website this year or next. And we also promote the guidelines within our own government. Remember, I mentioned that the guidelines apply to state-owned enterprise and crown corporations. Well, we also have to have some good due diligence. I would mention, before moving on to another slide, in terms of our promotion, we recently entered into a partnership with Global Compact Network Canada, GCNC, and if you go on their website, they should have right now, because it was launched in March, a new guide that they put together, and we supported them in doing that, where basically they have sort of summarizes the guidelines and the key due diligence guides for Canadian business, and putting it in a little bit more of a business friendly, hopefully. So if you're looking for a sort of a one-stop shop tool, that could be a nice place to go to. I could go on, obviously, talking about more promotion things that we've been doing and our policy coherence within government, but now I think we need to dig into cases, because I see that time flies quickly. Expectations on parties to a case. This is very important. We offer mediation. We need good faith. The good faith is described in the guidelines. Here, I have outlined a few of the expectations. An important one is campaigning. We are being criticized because we so-called ban campaigning on a case during the process. It's not that if an NGO files a case, it's not that we're preventing or forbidding them from carry on with their own activities, because or a union, they do campaign, but there is an expectation from us that you have to enter in good faith with the company and with the NCP if you want a positive resolution. So that's where also confidentiality breach can also derail easily a process. I'm going to move on because I'm looking at the clock and I digress a little bit. But if we move on to slide 14, a very key feature of the Canadian National Contact Point is that if a company chooses not to engage when there's a case, or they don't engage in good faith with us, they will face some consequences, i.e. denial of access or withdrawal of Government of Canada trade advocacy support by the Trade Commissioner Service here in the Global Affairs Department, or they could face denial of future financial support in foreign markets from Export Development Canada. And that consequence is made public in the final statement that the National Contact Point have to file at the end of each case. And we also inform other government actors, and basically Export Development Canada do take that into account in their CSR due diligence. We do forward them our reports on each case, and we're currently working with the Canadian Commercial Corporation so that they do the same. Moving on to slide 15. This is a very busy slide. If you go on our website, it will be a lot clearer, promise. But basically, this is in a nutshell how we treat a complaint from receipt of the complaint to the publication of a follow-up statement. And the core steps are basically we first of all look at the case, and we can work with the submitter to make sure that he has all the pieces. We need not hard evidence. We're not a court, but we need supporting documentation. We need things to work with. This process is predictable, so we outline everything in our procedures guide. We then alert the company, and we explain the process to the company as well, and we invite them to respond with information to the allegations, because obviously we want to hear what they have to say. And we also flag that on our website that we have a new case. Then we do an initial assessment, and for that we have a set of criteria which I will not go through, but they are in our procedures guide, and they come also from the OECD guidelines. And basically we look at the issues, whether they are, whether basically what we do when we do an initial assessment, we don't say guilty, not guilty, or we don't say this is really crap. We basically say, well, okay, there is a good a case here for a mediation, or no, sorry, we don't think this is appropriate. So, and we have to explain why, and then if parties accept, then they go into a mediation. We can facilitate things ourselves, but typically we would hire a mediator. If there is agreement, or if there's no agreement, or if we don't offer mediation, in all cases we have to publish a final statement online. So you can go to our website and read some of the statements that we have put out there. And now we are improving, and we are now going to publish follow-up statements starting this year on cases in cases where we recommend, to the company to do something. It's voluntary for them, but we obviously have a good incentive for them with our sort of threat of the sanction. And we also will publish another report to say basically whether there's been progress or not. So there is definitely a reputational risk for the company there, and an extra in terms of what we say publicly on them in our statements, and there's an incentive to move on. I realize that I'm probably taking a lot of time. I have 3 slides, and then I have on examples, and then I have statistics. And basically, I just want to say a few words about some examples. Again, you can read the final statement online for that case. It's Barrick Gold with its Porgera mine in Papua New Guinea, and there is this is a big mine. They have artisanal miner related issue, and they had very severe human rights impacts in terms of sexual violence, loss of life on site due to the presence of artisanal miners and women in particular on site, with sexual assault by security guards hired by the company. So basically, and there was also environment issues. So this was one of our most complex cases. It took a few years, but we did have a mediation. We did involve both parties in the choice of the mediator, which made a huge difference given the antagonistic position, between the Canadian NGOs and foreign NGOs and notifiers local notifiers that had filed the case. There was a confidentiality issue. If you talk to the notifiers and the company, you will have different versions of what happened, and then you will have the NCP version of what happened in our report. But it did bring some concrete actions that were agreed by both parties, and this is very important. Not all the issues were addressed, but there was progress made Next, slide 17, another interesting case, because this is the first time we applied the sanction, the quote-unquote sanction. Basically, it was a China Gold company, which is really Chinese but registered in Canada. And because China has no national contact point, we took the case. And it was in the autonomous region of Tibet. There was a big mine slide, a whole mountain slide there, and with significant loss of life and other issues. And basically, the company purely and simply ignored all attempts by the national contact point to get in touch with them. So after multiple attempts, we published our final statement and denied them the trade advocacy support if they wanted to appeal to that. And basically, in the final statement, we outline the road path to redemption, if I can speak like that. And we are aware that this sanction is having a concrete effect on the company. I guess I have to move on, but this is a bit of an example out there, key example out there that we use to talk about our sanction. Another more recent case was a mining company in Mali. We did facilitate ourselves, and it did result in improvement in health and safety procedure in the handling of lead in the laboratory of the mine. Unfortunately, we could not solve the labor-related aspect of the case, but this issue raised a very interesting due diligence case whereby the laboratory of the mine was run by another company. And so business relationship, subcontractor, and the mining company should have applied better due diligence in checking what was the health and safety issues going on in that laboratory. The company has to report back in 2018, and the NCP will issue, again, a follow-up statement. And I'm not going to speak in detail to the next 3 slides, but there are statistics about our cases. In slide 20, you see that we've had a bit of an uneven arrival of cases. So we've handled 20 cases so far, the majority filed by NGOs and the majority in the mining sector. And basically in the past 2 years, we've had 6 cases received. So we're basically more relevant than ever. And mediation or dialogue was accepted in 50% of the cases where we offered. So it's not, an extraordinary figure, but we think that with the introduction of the sanction, quote unquote, we will attract more companies to the table. I just wanted to say one word to conclude before opening up for questions, but global impact of NCPs across the 48 NCPs, we've had 430 cases, and the OECD is producing an annual report. So you're actually online. So you're welcome to have a look at, to have a better overview of what's going on and some of the concrete impacts of the system. Thank you.
Thanks, Pascal. That was a wonderful presentation, very, very informative. A number of questions have come through, and I'll read them out to you. The first 2 questions are sort of connected. In slide 14, you mentioned that if the company chooses not to engage, it can face denial of access or withdrawal of Government of Canada trade advocacy. And the question is, what can you give us the details of what that's about? And the related question is, does the U.S. NCP have similar types of powers to, deal with a company that refuses to engage? So if your comments on that, thanks.
Okay, so I'll second question first. The answer is no. The U.S. doesn't have that. Germany, we're pretty unique that way, and Germany is starting to look into that. I think they have a sort of a mini version of what we have, but it's very recent and I'm not sure. So trade advocacy, I mean, again, I wouldn't be, I'm not a trade commissioner, but I hope I'm not going into dangerous territory in trying to explain what that. But the way I understand it is that we're not denying or withdrawing the basic service, for example, provided by a head of mission in a Canadian embassy abroad to a company that wishes to develop and open new markets in that country. But it's the enhanced services which would be denied or withdrawn, and that's more like customized and individual for that company. For example, a ceremony where you would have, or an event, public event, where we'd have just the Canadian ambassador, say, or a trade commissioner from Canada, just with that company, introducing them to the local government. But so it's individualized, enhanced services. So again, it is not cutting everything. We possibly cannot do that, but it's only a particular category of upgraded services.
Thanks. The next question is, can a Canadian company that's having difficulties regarding human rights abroad come to the NCP to ask for assistance? And they say, what we often see is that a company is falsely accused of human rights or environmental breaches, which affect their reputation and often the integrity of their operations abroad. And they need help of an independent body to work with the stakeholders. So it's the opposite of, I guess, your usual situation where it's the foreign stakeholders complaining. Here it's the Canadians saying, we need your help to mediate.
Yeah, that's a good question. So basically, the NCP can and does, as I mentioned, as part of its mandate, we do promotion and we do, dissemination of material. We're not going to, however, we are not designed to entertain the reverse, i.e., this situation where we would actually actively take the request of the company and ourselves reach out to the local stakeholders and offer that mediation. We have our processes and mandate comes from the guidelines, and they are designed to do the reverse, as I explained. But there are other tools and probably doors where the company could go and knock at, because as part of the Government of Canada approach to responsible business conduct, and with the new announcement with the new Ombudsperson by the minister, we're also having a more sort of enhanced responsible business conduct approach and strategy. There are other tools. The counselor, the CSR counselor, which will be sunset, if I can say, was one of those doors where a company could talk to, but they can also talk to the post. They can talk to the Canadian mission in the country where they operate, and sometimes there is a CSR expert depending on the post. But I'm not saying that this is necessarily everywhere. But we in Global Affairs, we do training of trade commissioners and Canadian missions abroad on the responsible business conduct and the various tools that are available out there. They could also reach out directly here to Global Affairs, not the NCP, but colleagues in the responsible business conduct unit, or through our online presence in terms of accessing some tools and guidance.
Thanks. The next question is, can you break down how many cases have occurred in the third world countries versus the developed world in terms of the cases you've seen?
In terms of Canadian cases, I'm just trying to flip to find the exact number. I'm not sure if I have this handy, but the majority of our cases is in so-called third world or developing countries. We have basically we've had cases in North America, actually Canada, so to speak. We have right now an ongoing case which will go to mediation. That is about a Canadian company in Canada, and the case was filed by a U.S. NGO. And but I would say it's largely in the African and Southeast Asian or Eurasian region. in terms of our own statistics, and only 3 in Latin America, actually, which would be expected maybe to be a bit more given the Canadian mining presence in Latin America, but we've had only 3 cases. Now, something that I didn't mention, as part of the many things that I didn't mention, but if a case arises in a country which has an NCP, i.e. Mexico, Chile, Costa Rica, Peru, Argentina, Brazil, to talk about Latin American countries, then it's the NCPs of these countries that will deal with the case, even if it's a Canadian company. And so they're the lead, and we could support them.
Okay. Next question. You talked about suppliers to Canada, suppliers to Canadian companies, where the suppliers are in breach of human rights. Do you have any complaints or cases that you're dealing with currently around those issues?
No.
No? Okay.
That's a short answer. No.
One of the issues you raised was that companies need to comply with the human rights laws of the host country that they're in, and what we've seen in a lot of situations is where the host country's laws or directives require breach of those human rights. An example, for example, the Vodafone issue in Egypt, where Vodafone was ordered to close all communications at Tahrir Square. That conflicts with human rights. What do you do in terms of what's your perspective as the NCP on issues where the human rights are breached because the local law requires it?
Yeah, that's an excellent question that pops up regularly, not so much in the cases that we've had so far, but I think it's only a matter of time, especially with the IT sector, right, and the telecom sector as the Vodafone example and others. But other NCPs have started to have cases like that. Well, basically, in the concept and principles chapter of the guidelines, there is in section 2 there on page 17, for those who like to go back to the text, but basically says that expected or not, companies are not intended to place, the guidelines are not intended to place a company in situation where they faces conflicting requirements. But, however, when there's a contradiction between the principles and the standards in the guidelines, i.e. the human rights, due diligence and the human rights obligation that, a company should respect human rights, if there is a contradiction there, the enterprise should seek ways to honor such principles and standards to the fullest extent. Now, they also basically have, to take a very blunt answer, the company has the option to walk away from the contract that they have with the company or the host government altogether. But basically, it's not because they have opted to do business with these kinds of countries that they should not follow the guidelines. They have basically they are supposed to honor the guidelines and the human rights and respect human rights in their operations to the extent possible. To the fullest extent possible. And that's really, there is a gray zone there because obviously this is not necessarily easy to quantify, but then it becomes a judgment of what the company decides to do and not to do ultimately. But a human right, that's why they need a human rights impact assessment in the first place, and do a reflection on how they want to mitigate those risks or direct impact.
Oh, thanks. And we have time for one last question, which is, will the use of blockchain applications reduce regarding issues associated with conflict minerals such as cobalt and diamonds, make the NCP activities more relevant in arbitration cases? I'm not sure if you can comment on that because you may not have the familiarity.
No, I guess it's a prospective question. I think the NCPs will see more and more, I don't know if that's answering the question, but the NCPs will see more and more cases with respect to supply chains of conflict minerals. And as I said earlier, I think there is a buildup of jurisprudence that's happening that will basically not restart the clock to zero each time, but that we have to, as NCPs, we have to consider what other NCPs have done and build on that.
Okay, thanks very much. I think with that, we conclude the formal part of the presentation. So on behalf of all the participants and on behalf of the Athabasca University Faculty of Business, I really want to thank you, Pascal, for this wonderful presentation on the NCP system in Canada. And I also want to mention that I've spoken to Canadian Global Affairs people who are in charge of the new CORE program, and they've agreed to provide us with a seminar on that program once it becomes operational, probably in September of 2018. So I look forward to that and hope that those of you in the audience will join us for that. If you look on the right side of your screen, you should see an icon for handouts, and Pascal's PowerPoint presentation is now available as a PowerPoint to anybody who wants to download it in order to review it afterwards. So thank you everybody for participating. Thank you again, Pascal, for the presentation. And this concludes the seminar. Thank you.
Thank you.